Hello, Bob. Thanks for agreeing to meet. I've received your markup of our contract and would like to go over some of the edits you made.
Oh, the awful agreement. Yes, let's talk about it. I can tell you it's the worst thing I've ever seen. I nearly fell off my chair when I saw those terms. And those rates. Please, do your actuaries think they're smarter than attorneys?
Well, Bob, we'd love to work with your company. I suggest we review the agreement together and I can explain our rationale for these terms. Let's start from the beginning. I see that you deleted a comma in the preamble of the agreement.
It was completely out of context and I'm a stickler for grammar. Do you even know what an Oxford comma is? Can you name all 13 kinds of punctuation in the English language?
Okay, if you feel strongly about it, we'll agree to that change. Let's move on to the limitation of liability paragraph. I see you've entirely deleted it. Can you please explain your objections?
I think it's just ridiculous that Milliman isn't willing to stand behind its work. We don't allow our other vendors to limit their liability, why should we let you? Don't you stand behind your work?
We do stand behind our work. However, we've seen competitors incur firm-threatening claims and have come to realize that it is no longer viable to take on unlimited liability in every project. Our risk needs to be somewhat proportional to the size of the project. Our insurance carriers have also taken notice of the increased risk and our premiums have increased dramatically. In order to provide quality, meaningful services to our clients, we need to take reasonable steps to mitigate our risks.
Well, I do hear you on the insurance issue. I think just about everyone is encountering those issues these days. I guess I am okay with that change.
Okay, then the next thing to discuss is the arbitration clause. I see you've deleted it completely. Can we talk about that?
We never agreed to arbitration. It's ridiculously expensive, especially with 3 arbitrators. Why not just use the courts? What's wrong with jury trials? I love juries and they love me. Haven't you ever seen Keanu Reeves in The Devil's Advocate? I just love that movie. Hoo-ah.
Hoo-ah. Isn't that Pacino from Scent of a Woman?
Are you trying to tell me I don't know Pacino? I know Pacino. Hey, you talking to me? You talking to me?
That is not even Pacino. That is Bobby De Niro and Joe Pesci.
You were wrong. Hoo-ah.
Alright. Back to the issue at hand. We've found time and again that the average layperson doesn't even know what an actuary does, let alone understand the complexities of the claims brought against actuaries. We are simply asking our clients to agree that it is reasonable to use adjudicators who actually understand the issues. We can address your cost concerns by talking more about allocation of the costs, but our board requires that we obtain a dispute resolution provision which avoids jury trials. Do you think we can come to agreement on that?
Look at me, I could have had class. I could have been a contender. I could have been somebody, instead of a bum, which is what I am, let's face it.
I am pretty sure that's Marlon Brando in On the Waterfront, not Pacino.
Maybe you were right. I am all confused. I barely understand what actuaries do, so I guess I can see your point about the juries. Can we try mediation as a first step? It's less expensive and as long as we can work out the cost issues, I suppose we can consider arbitration for this contract as well.
Great, I really appreciate your flexibility. We also agree that mediation can be a very effective tool for resolving disputes, so we are happy to add that language as well. The other issue I believe we need to discuss is our no third-party distribution provision. I see you've deleted everything but the first sentence. Can you please detail your concerns?
Well, we were paying for the work and we own it, so we should be able to do whatever we want with it. I think it's absurd that Milliman wants to prohibit us from giving it to any third parties. We need to give it to our lawyers and probably our auditors and who knows who else.
Well, we certainly don't mean to prevent you from being able to conduct your business in its normal course. We can add specific language in the agreement to allow you to distribute Milliman's work to your service providers, such as lawyers and your auditor. However, We intend to only have a legal duty to you, our client. If third parties receive our work and rely on it to make financial decisions, we incur the risk of being sued by those parties, so we would require them to first sign a release agreement before receiving the work. This is why we require the client to seek our prior consent before distributing the work product.
Well, our people sure do like that Mark Mahaney. Also, I heard he invented the internet and Cool Ranch Doritos.
Yes, he is a wonderful person and a gifted consultant. As for the internet and Cool Ranch Doritos, I am not sure.
Yes, he does great work, and Milliman has a very good reputation, so I guess as long as we can give it to the lawyers and auditors, we can probably live with the other language.
Okay then, let's talk about the choice of law provision. I see you've changed it to Florida choice of law.
Yes, I thought it was outrageous that you wanted to use New York law when we were located in Florida and Mark is located in Connecticut. I don't want to have to go to New York to settle a claim. The hotel rates there are nearly as high as your actuary's rates, and I don't know anything about New York law. What does New York have to do with this agreement? Are you guys incorporated in New York or something?
Well, the intent of that clause is not to settle the claim in New York. We have no problem with conducting arbitration in sunny Miami, especially if you sue us between September and March. However, our counsel has advised that the case law in Florida is very hostile toward limitation clauses, and because the parties have agreed to this language, we need to ensure that it will be enforceable. We could agree to apply Florida law to the agreement but add language relying on New York to enforce just the limitation of liability clause. Would that be acceptable to you?
So New York would only apply to that one clause. Florida law would apply to the rest of this contract.
Yes.
Okay, we can agree to that. Anything else?
No, I think that's all. It's been a real pleasure negotiating this agreement with you. I'll make those changes right away and get you a new contract for signature.
Hoo-ah.